Good, good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Let me turn off that little speaker there so you don't get that hideous feedback. But I want to thank everybody for joining us. We're going to give it a few minutes here. Well, a few people arrive. We have a great show for you tonight. Obviously, a lot has taken place today. We've got the Kare Read matter. So for all the Kare Read can do no wrong group and the Kare Read can do no right group, get ready. We are going to call it right down the middle, tell you the facts just the way we see them, and whether, Alan Jackson may need to maybe realize that his April may be free here really soon. So we've got that going on. And also, we're going to talk about the Brian Kohberger matter. As you may recall, the transcript was unsealed. This is the one that the government, everybody wants sealed. I think it's a complete joke that anyone thought that there was any reason whatsoever to have a closed secret proceeding not available to the public. It's ridiculous. If this is what they think, I can only imagine the ridiculousness of the matters as it relates to Chad Daybell and Lori Vallow, all the hearings that they had in closed chambers where the public couldn't see the proceedings. Anyway, I'll go through this transcript. There's a couple of little interesting things we knew about, the unidentified DNA, but they don't go into it because they were trying to do this hearing about the genetic genealogy and the DNA. And frankly, when you read all 174 pages of it, which I have done so that you don't have to do it yourself, I'll hit the high points for you. But obviously, we know from the orders that the judge issued in the Brian Kohberger case. You see, I've got all this paperwork here because it's important. We got to reference it. We want to go straight to the source. Anyway, all of those orders, the defense for Brian Kohberger got zilch, nada, nothing. You get nothing, sir. Good day. Move along. And it's almost like, and when you read all the briefs and everything, it's a great law review article of maybe where the law should be going on expectations of privacy and things of that nature. But it's just not there. The law is not there yet. And let's face it, and I've said this from all along. Now, there's lots of people that say, "Oh, Scott, you're getting hung up on DNA, whether the DNA was on the little, tab here, or whether it was inside here or here." The point is, it doesn't matter. It's DNA. Your client's DNA in the sheath underneath a body where a quadruple homicide has taken place. Now, you can say, hey, these things happen. You never know who was in that house, who was there. Maybe it was planted, right? Remember early on, the police planted the knife sheath. They planted his DNA to get him. And then, of course, you have to say, okay, but why would they want to frame Brian Kohberger for such a crime, right? I mean, we can talk about that. Please, we can talk about that. But anyway, 174 pages of transcript that people thought this needed to be a closed hearing. I'm telling you, there was nothing shocking in there whatsoever. Frankly, the defense didn't get the answers that they were looking for in that particular hearing. And like I said, it didn't go well. And so they lost all their motions. The whole point of the defense strategy was to attack the investigative genetic genealogy, to say that everything that was obtained, that was somehow obtained illegally in violation of his right to privacy, even though you've abandoned your DNA, right? You've abandoned your DNA. How can you really claim that? In fact, it's interesting. The judge noted that they never said that it was his DNA, that he has this expectation of privacy. So let me give you a quick example. All right. Let me give you a quick law school example. Right. Let's say I hypothetically am I have a backpack and I'm walking along the street and I have large quantities of illegal controlled substances in my backpack. And in that backpack, like always is the case with the backpack and the large quantity of controlled substances, there is an ID. So let's say hypothetically, controlled substances in a backpack, my backpack, right? Not good, right? But I see the police officers coming down because I shouldn't have the controlled substances, right? And I have my backpack and maybe something to show like my water bill or something to show like, it's my backpack, right? I see the police officers coming in and walking at me and they're looking at me. I'm looking at them, right? They're doing the thing. And all of a sudden I take my backpack and I throw it into the bushes, down the little ravine and into a little creek. And I start running. And the police officers get me. And then they go back and say, we think that something was thrown over here. And sure enough, they find the backpack. And they find illegal drugs. And I say, hey, I get charged with that. I want to go to court. You guys illegally searched my backpack. That was my backpack. I have an expectation of privacy to that backpack, right? The prosecutor's going to say, he has no expectation of privacy. He abandoned that expectation of privacy when he threw the backpack. And unfortunately, it had his license in there and it had all these controlled substances. And next thing you know, Scott is on Crime Talk's Dumb Criminal of the Day, right? And that was really kind of the argument that the prosecution or the defense was making in the Brian Kohberger matter. Sure, you may have found my DNA on the knife sheath underneath the body at a quadruple homicide. But hey, I have an expectation of privacy to my DNA, not the sheath. I'm not claiming ownership of the sheath, but my DNA on the little button right there. The court said, no, you abandon your DNA at the crime scene. Just like in my example, I threw my backpack. That was the crime scene. I threw it. I abandoned it. It is no longer, I can't say I have an expectation of privacy. Maybe if it was on my person, right? Could say, hey, will you give us permission to search your backpack? Nope. Well, we're going to just kind of look through it for officer safety. And then I open it up and see, maybe I got my K-bar in the back. Oh, it's a dangerous weapon. I need to search more, make sure I don't put my hand in there and, cut myself on it. Right. But the point is, so that was the whole thing there. So we can talk about that. Still waiting for, a couple more 100 people to show up here, hopefully tonight. But a couple of things we want to talk about. Obviously we got the Kare Read. I left something on the printer in my stack of stuff to talk about. But first, there was a case, the Richard Glossip, Glossip case. I think it's kind of interesting because the United States Supreme Court orders a new trial for this guy after this guy has been on death row for decades. All right. So what happened in this particular case? So on Tuesday, today, because we're doing our live, it's Tuesday Night Live, the Supreme Court ordered that an Oklahoma man who was convicted of murder, who has been scheduled for execution 9 times and served his last meal 3 times, gets a new trial. That's right. A 5-3 decision has basically seen this case go back and forth and appeals and challenges particularly as it relates to the constitutionality of lethal injections and cruel and unusual punishment. But the Supreme Court concluded that the prosecution violated its constitutional obligations to correct false testimony. Justice Sotomayor wrote in her majority opinion, invoking the 14th Amendment right to due process. There is those little technicalities, right? Technicalities, due process. Anyway, they reversed the judgment below and remanded the case for a new trial. Judge Gorsuch did not participate because he was an appellate court judge at the lower level when he was a 10th Circuit judge, because this case originated out of Oklahoma, and it would have been the 10th Circuit. So he participated in that. And in this particular case, Roberts, Kagan, Kavanaugh, and Brown joined Sotomayor. Clarence Thomas and Alito and Comey Barrett did not go along with the majority opinion. So Glossip was convicted by an Oklahoma jury for involvement in the 1997 murder of his former boss, a motel owner by the name of Barry Van Treese, only by testimony from the confessed killer, Justin Sneed, who later recanted the claim that he was paid by Glossip to perform the killing. He has maintained his innocence, and there was no physical evidence. Now, Sneed, who received a life sentence in exchange for testifying against Glossip, had been diagnosed with bipolar disorder and had been taking psychiatric medication, but denied it during trial. Facts uncorrected by the prosecutors who knew the truth. Guess what? Kind of coming back to something we're talking about here today on the Kare Read thing, right? Anyway, had the prosecution corrected Sneed on the stand, his credibility plainly would have suffered, the justices wrote, and that correction would have revealed to the jury not just that Sneed was untrustworthy, but also that Sneed was willing to lie to them under oath. Such a revelation would be significant in any case and was especially so here, where Sneed was already nobody's idea of a strong witness. The attorney general there in Oklahoma, who's a death penalty advocate, came out actually against the execution after reviewing the trial record. That was the state Republican Attorney General, Genter Drummond. Drummond stated that it says the death penalty doesn't turn on, ideology or politics. It should turn on the rule of law. And this has been a wildly unpopular position for me to take, but it is the right thing to do, Attorney General Drummond said. And he said he does not believe Glossip is innocent, but that a new trial is imperative. So, obviously, the attorneys for Glossip said that they're thankful that the clear majority of the court supports longstanding precedent that prosecutors cannot hide critical evidence from defense lawyers and cannot stand by while their witnesses knowingly lie to a jury. That's just the right thing to do. This guy's been on death row for like 20 years, 9 executions dates, 3 last meals. And somebody finally gets around to saying, but that guy lied. And the prosecution has an ethical obligation to let the jury know, which goes back to the whole point of prosecutors, ladies and gentlemen. Their job is to do justice, not just to get wins. And that's really what this case came down to in this particular case. So, Mr. Glossip, who knows? Maybe he'll get something other than the death penalty. Maybe they'll resolve it before they get there. Who knows? It's an old case. Trying to get witnesses back may be difficult, but it really doesn't matter because it's sworn testimony, been subject to cross-examination. So therefore, under Crawford v. Washington, they can just basically have somebody get up there and read the transcripts of the witnesses that testified some 20 years ago if they are no longer with us. Okay. Which brings me to my next point. Let's talk about the Kare Read case. All right. And then we'll get to the Kohberger matter. So Kare Read, accused of killing her now deceased boyfriend, former Boston police officer, O'Keefe, right? Apparently they go out for a night of drinking with some friends. They meet up. She apparently wants to go home and drops him off at kind of an after party after the bar at a bunch of police officers' house. She goes home, but gets a little worried the next day, right? Comes to find out that he's found dead outside the home where he dropped him off, which is fellow police officers. Did she hit him, run him over, leave him to die in the cold? Or, was he attacked by his fellow police officer friends at this after party where they let the dog attack O'Keefe and throw him outside and let him die in the cold? Obviously, the defense theory was the latter, that she's been framed. She's an innocent woman. This is a travesty of a mockery of a sham to this case to even go forward. Well, the jury hung back in July. And then there was a whole issue where the jury said, but hey, we'd actually reached verdict on 2 counts. We would have found her not guilty. It was a third one. But the jury never said, we've reached a verdict on 2 counts. We're only hung on the third. They said, we are at an impasse. We cannot do this anymore. The judge gave an Allen instruction at one point and said, go back and try again. They said, we are at an impasse. We just can't decide. Judge says, fine, mistrial. But before that took place, neither the prosecutor nor the defense nor the judge said, hey, should we ask them? Should we ask the jury if they've reached a verdict on any of the counts? But nobody bothered to ask. So the defense says jeopardy should have attached to Kare Read's case. She should be found not guilty. She should only go to trial on the remaining count that the jury was hung on. The judge denies that request. It goes up through the appellate courts. The highest court in Massachusetts said, no, nobody asked. It's a waiver. You can't come back and do it. And so then Kare Read, through his attorneys, I can't remember if it was late last week or early this week. I think it was last week because that's when everything all blew up. It was the same day that, the judge was not pleased and had concerns, not just regular concerns, but grave concerns about the conduct of the attorneys in the case, right? So they filed a habeas petition in federal court. It's not going anywhere, ladies and gentlemen. Not going anywhere. So for everybody that says, I hate Kare Read, I don't hate Kare Read. I have no dog in the fight. Frankly, the more that goes on in the Kare Read case, the better. The more interesting conversations that we get to have about the Kare Read case. But the reality of it is the habeas stuff is going nowhere. I will bet you $1 on that. All right. Bottom line, going nowhere. The courts have ruled on it. She's still, I'm not sure she's exhausted all of her remedies that she has to do to get into federal court on the habeas petition. It's very strict on the habeas laws. I can tell you, we've only done one habeas petition. I was kind of helping somebody on it, and it's a world unto itself. Okay, very specialized, highly specialized area of law. Not my area of expertise. Like I said, done one. And like I said, I was more of a consultant for the attorney that did that because they were not familiar with a lot of the state court procedures as well as the local federal stuff. But anyway, we got it. It went in. But you have to exhaust all of your remedies. Here, she hasn't exhausted all of her remedies. She's got an appellate court. Frankly, there's still basically like an ineffective assistance claim that she can make against her attorneys for not arguing it. So I think it's going nowhere. Anyway, we digress, right? So let's get back to the focus. So what comes out at the trial? At some point, the feds, the United States Attorney's Office there in Boston, is looking into this case. And they're trying to see if maybe there's some federal crime that's been charged, police misconduct, all that kind of good stuff, right? So they hire these ARCA people, ARRCA, and they are apparently witnesses they've been paid consultants for the United States government. At some point, their contract expires. The feds are really tight. They're playing it close to the vest, saying, well, there's this stuff. But at some point, the defense says, we're going to call these ARCA people. And the judge says, really? You're going to call expert witnesses that you haven't talked to? You may not even really know exactly what they're going to say. And you're going to call them as a witness? And the defense is like, yes, judge, because we are just here for the truth. And we believe the truth is going to come out. Okay? Like I said, case mistries. All right. So we're coming up on the second trial, coming up here in April. And if you follow this stuff or you're familiar with the court proceedings, if you hire expert witnesses, you have to disclose that they are hired expert witnesses, whether, it's a civil case or a criminal case. You have to disclose these issues. You have to disclose that they're being paid, right? They always ask, and isn't it true, Mr. Expert on the witness stand, that you were paid $1,000 per hour for your time? Yes, it is. And the other side says, you're highly trained and experienced, expect to get paid, but $1,000 an hour, my God, that's outrageous. You're just a whore. And you would say anything for $1,000 an hour, wouldn't you? No, I'm here for the truth. But you have to disclose that, kind of like when your witness says that he's not on his, medications, like in the death penalty case, right? And the prosecutor knows he's suffering from mental illness and he's not on his meds. It means that he's a liar. And the attorneys couldn't sit silent and let that go by. They had to correct the record, and they didn't. So in the Kare Read case, Mr. Jackson, the lead attorney, admitted pro hoc vice in the great state of Massachusetts, or the Commonwealth, I guess they call it, the Commonwealth of Massachusetts. From California, Mr. Jackson rolls in, and he even asks the witness on the witness stand, have we ever met before? No. Have we, talked to you about your testimony here before? No. Why are you here? We're just here for the truth. So, like I said, the case mistries. New prosecutor comes on, this Mr. Brennan guy, and he starts kind of digging. And he starts sending basically kind of like these FOIA requests, these TUI requests to the feds and saying, hey, can we get this? Can we get this? And so the feds are like, okay, we're going to turn over some stuff. But now the defense says, you know what, we're going to call these ARCA people again. And well, we may have paid them like $24,000, maybe $24,000. Right? So this comes up at the hearing last week where the judge stopped it because Mr. Brennan gets up and says, hey, I got this stuff. I got all this stuff from, the United States Attorney's Office. And look, there's emails where Mr. Jackson and other attorneys are talking to this Dr. Wolf, and they're talking about what they should say on direct examination. Can't do that. Particularly when you make representations that, have we ever met? Have we ever prepared any testimony together? Have we paid you any money? No, we're here just for the truth. So the defense turns it over, and Mr. Brennan says, I'm sorry, Judge, I misunderstood. I thought we got it from the United States Attorney's Office. We may have got it from the United States Attorney's Office, but we also got it from the defense. And they turned it over that there were these emails from before, as well as the bill. Now, of course, the Kare Read can do no wrong camp says, Kare Read can do no wrong. They're just trying to get Jackson off the case. This judge hates Cannon, however you pronounce her name, doesn't really matter. The judge, everybody from the Kare Read can do no wrong camp says that the judge is just trying to get Alan Jackson off the case. And the Kare Read is guilty camp is like, no, Alan Jackson is unethical. He lied to the court, etc. Right? So the judge finds out about this, and she says, I have grave concerns. We're going to take a break. And she issues an order. I think I got that one right here, too. No, that's not it. I think I've got it somewhere. Anyway, it basically says, hey, we're going to have a hearing next Tuesday, and we're going to discuss. Everyone should be prepared to discuss these communications and payments to this ARCA consulting group, who coincidentally had taken down their X page. Anyway, where is the big issue then, right? You know, sometimes people misspeak. They, what's the big deal? Well, the point is kind of like the whole situation of this Glossip guy down in Oklahoma. It's called a duty of candor to the court. Okay. Rules of ethics and responsibilities. Right? You have a duty of candor to the court. You can't make false statements of law to the court. Right? So if you know that there's case law completely against your position, you have to disclose it to the court, even if the other side hasn't found it yet. You have a duty to the court. Candor of facts about the case. An attorney is subject to discipline for knowingly making a false statement of material fact to the court. Ordinarily, an attorney is not required to have personal knowledge of the facts stated in pleadings and other litigation documents. Those contain assertions made by the client or by those other persons, not by the attorney. But when an attorney does make an assertion of fact to the court, the attorney is expected to either know that the assertion is true or to believe it to be true based upon reasonable, diligent inquiry. Further, an attorney's failure to speak out is, in some contexts, the equivalent of an affirmative misrepresentation. Now, here's where it gets a little tricky for Mr. Jackson. And once again, the haters, last week I said, this is not good. If I was Mr. Jackson, the little pucker factor would be getting a little tight right about now, right? Like, ooh, this isn't good. The judge thinks I did something unethical. You don't want to be that guy where somebody says that you did something unethical. And I said, and people said, oh, Scott, you don't know what you're doing. You just hate Kare Read. You're always so negative against Kare Read. I said, if I were Mr. Jackson, I would not do this hearing on my own, and I would get myself some new counsel. I would get an attorney regulation kind of counsel. All right? So who shows up today? Well, obviously, Mr. Jackson was there. The other female attorney was there as well. But they brought in this Mr. Alisi to the case. Now, this hearing started, I don't know, what was it, like 10 o'clock Boston time or something like that, maybe a little later. But they take a break. They stopped at 4 o'clock. But the Alisi guy goes on and on and on. What's the Hamlet quote, right? I think the lady does thou protest too much. This Alisi guy makes literally like a 4-hour argument. I'm literally just like, are you kidding me? This is crazy. Wrap it up. This is like a 20-minute argument. And Brennan, the prosecutor, when he finally got his time, He wrapped it up in like 20 minutes. And they were splitting hairs. And he was like, well, Judge, there's no misrepresentation here. But if there was a misrepresentation, what's the big deal? What's the big deal, Judge? And even if you find that there was something wrong, you need to sanction Mr. Jackson after these court proceedings. Don't take away his right to be admitted pro hoc vice. Wait until after the trial and then make the appropriate sanctions against Mr. Jackson. And what do, right? I mean, the judge, she's got to make a decision. She can say, make a finding that there was a material misrepresentation. And what she is concerned about, and I watched the hearing today. I may not have done it here. I was at my desk, but I was listening to the whole thing and watching it on another computer. They were splitting hairs. Well, Judge, I mean, come on. We all want the truth to get out, right? And what does it matter how it came out? And so what? Maybe we did pay these guys. We hadn't paid them before they testified. And apparently at a little sidebar, which also got the judge's attention, apparently the judge asked Mr. Jackson directly, did you pay them for your testimony? Last week, she asked him this at a sidebar. And what does he say? Because remember, the judge took a break after Mr. Alisi gets done, and he basically volunteers for them to answer questions. And she says, I got a couple of questions. You know, I asked you at the bench conference, had you paid them? And you said you had not. And Mr. Jackson jumped up, Judge, I stated I did not pay them for their testimony. I compensated them for their time. You tell me, ladies and gentlemen, was that a material misrepresentation of fact? You paid them for their time, which included the testimony. You now have to disclose it now that you're hiring them again, basically, or you're going to compensate them up front this time to come testify. And frankly, had they just said, we're going to pay these people time because we like the results that we didn't ask them to do, but we're going to do it, and we're going to pay them for time because professionals expect to be compensated, we wouldn't even be here. And this is what happens when you get cute. I've talked about this before. I always tell my young attorneys, never met a client worth going to jail for, and I've never been paid enough money to jeopardize my law license. Now, do I think that Mr. Jackson is going to lose his law license? No. Do I think the judge will revoke his pro hoc vice, which is his ability to practice law in the Commonwealth of Massachusetts for this particular case? I don't know what the judge will do. I think she let the defense make their record and argue. And like I said, thou protest too much. Instead of getting up and saying, Your Honor, what's the problem? There was some coordination, oh, gee, we, a lot of attorneys on the case, something got handled. We didn't know about it, whatever. But it was directly from Jackson to them. So he can't deny that, right? Judge, what's the big deal? Yeah, of course we coordinated a little bit, but we hadn't retained them. We paid them after the fact. So what's the big deal? Move along, Judge. We did nothing wrong. And guess what? Ms. Kare Read has a Sixth Amendment right to counsel of her choosing. And so what are you going to do? Create reversible error if you kick Mr. Jackson and his team off, since 4 of her attorneys are not licensed in the state of Massachusetts. There's one being their sponsor, kind of local counsel, who's supposed to tell them how things are run. I mean, I've been admitted pro hoc vice, New Mexico, Oklahoma, South Carolina, North Carolina, South Dakota, Wyoming. You always got to get local counsel. Helps you out, keep you honest, so to speak, what the rules are. How do we format this thing? How's the local procedure done? It's the best money you ever spent when somebody hires you to go to another jurisdiction to do that. But you better do everything right because you're already the outsider. Like, oh, what? There aren't any good enough attorneys in this town. We had to hire somebody from out of state to deal with this, right? So the judges already are looking at you a little skeptical. Oh, really? You're better than all our local attorneys out here? And you have to, well, Your Honor, I just privileged to be here. It's an honor to be here. Worked this case early on. We didn't expect it. If anything, we thought there was going to be indictment, here, but now it's there, whatever. So will the judge take away his pro hoc vice as well as all his other attorneys? Interesting question. The defense did cite a couple of cases where the court kicked off attorneys that were pro hoc vice prior to because of misconduct, and basically it resulted in reversible error. But remember, pro hoc vice is a privilege. I mean, you have to fill out all the paperwork. The other attorney kind of sponsors you. You have to submit stuff from the bar saying, look, I'm in good standing here. No complaints. I promise to abide by all your rules. I'll be very nice. And please allow me the privilege to practice in your court. I don't think you have a right to pro hoc vice counsel. There's plenty of good attorneys, I'm sure, in the Commonwealth of Massachusetts. But does it create error, or does the judge even care? Or does she say, you know what? I'm going to find that there were material misrepresentations. There were material misrepresentations made after or to this court, and I'm going to let you proceed, right? And I can come up with some other sanction, like maybe not allow the investigators to testify again. But then that goes to the defense's right to present a defense, due process. Don't do that, right? Sounds like it's ripe for cross-examination. If I were those experts, I'd be like, I don't want to be anywhere near this trial anymore. Sorry. Yeah, I'm out. Not going to testify, right? So the judge is in a tight spot. So I kind of agree with the defense. They're arguing, well, judge, there's no big deal. I mean, look at, look over here, judge, there's nothing going on. Look over here. But if there was a problem, judge, and you think our attorneys weren't completely candid to you, don't revoke our pro hoc vice status, because one, it's going to delay the proceedings. Kare Read's going to have to get new attorneys. She's entitled to the counsel of her choice under the Sixth Amendment. So don't do anything. So the safest thing for the judge to do would be to say, fine, I'm going to make these findings, and I'm going to allow the prosecution to go in the fact that this wasn't disclosed, that you guys communicated and you paid them for their time, and they're going to do it again, and that neither side was honest. Just let the prosecution go into it on cross-examination, and the witness is just going to have to say, yes, that's all true. That's all true. That's all true. And so you colluded with this man. You admitted that, you said on the witness stand under oath, under the pains and penalties of perjury, that you were not being compensated. You didn't expect to be compensated. You were just here for the truth. Good Samaritan. When in reality, you submitted a bill. Wow, that doesn't really sound like submitting, just doing it out of the goodness of your heart, does it now? Oh, and you're being paid for this time around as well? Let them, prosecution, just go. I mean, it's totally ripe for cross-examination. And then the judge says, whatever the case is, whether it's, an acquittal for Kare Read or she's convicted, and then they go to sentencing. Everybody's packing up their briefcases, and guess what? The judge says, oh, Mr. Jackson and team, we are not done here. I'm going to find that you all are in direct contempt for making misrepresentations to this court. And I'm going to sanction you, and I'm going to make sure that this gets sent off to your bar in California, as well as here, since you're subject to this jurisdiction's rules. And, have fun dealing with that. That would be the safe thing for the judge to do. The bold thing would be to say, Mr. Jackson, boom, you are out of here. You're out of here. All right. Does that explain it? Does that explain what's going on in the Kare Read case? I mean, I probably took a little long to do that because now I want to move on to the Brian Kohberger matter. Okay. Obviously, Brian Kohberger charged with 4 counts of homicide. They're in old Moscow, Idaho. He's represented by some very competent attorneys. Ann Taylor, Jay Logson, Alyssa Masseth, and they have a new attorney that's coming on, Pro Hoc Vice. Bicca Barlow is admitted Pro Hoc Vice in this case. Ann Taylor serves as local counsel, whose attendance shall be required at all proceedings. Okay. So Pro Hoc Vice is not it. Anyway, they have this hearing back on January 23rd. Of course, it was secret. It's just, I've never seen anything like it. Never seen anything like it. You can go into any courthouse, except maybe in Idaho. And I don't care what's going on. There could be a motions hearing. It could be a homicide. It could be a sexual assault. It could be a sexual assault on a child. They're having a child hearsay hearing. The child will be testifying on the witness stand. And you, Joe Blow, member of the public, can walk in, sit in the gallery, in the courtroom, and watch the proceedings. The victim's name will be public information at that point, because they'll say, do you swear and affirm, state your name for the record, right? Spell your name for the court reporter. All that good stuff, right? Anybody can go in there, no matter how embarrassing, personal, the circumstances of it. I don't care if you walked in and it was divorce court, a civil trial. You can go in and watch the proceedings, and they're not going to kick you out, maybe with the exception of a juvenile matter. That's it. But in this great state of Idaho, oh no, we think this could be affect the jury. Hogwash. That is the biggest bunch of garbage I've ever seen in today's world, in today's news cycle. People that show up for jury duty, you're going to find 12 people, good and true, otherwise unemployable, who cannot get off of jury duty. All right. That was a joke. Jury service is a great thing to do. It's one's civic responsibility. But I remember had a professor in law school that made that joke. Yeah, we're going to go to the jury system. 12 people, good and true, otherwise unemployable. Couldn't figure out how to get out of jury duty, right? Usually you're stuck with college students and old retired folks that want to be there, right? So this nonsense of, we're going to tape the jury pool. It doesn't matter. You're not taping the jury pool. Somebody can say, you know what? I have read about this case. I have read everything I can. I read it all. I've watched it all. And let me tell you one thing. I don't know what happened. But I sure like to hear the testimony of all those witnesses subject to cross-examination. And I think that would really be a great truth-seeking tool for me to find out. So although I've read everything about it, everything I get my hands on, by God, I would make one hell of a good juror, because I just want to hear it under oath from the witnesses that were there. So this nonsense that we're taping the jury pool, hogwash, nonsense, ridiculous, okay? No, particularly in Boise, it's a big enough city. You're going to find somebody, and you can always expand it. So anyway, they have these proceedings, and it was evidence related to the IgG, the investigative genetic genealogy. All right. They've stipulated to their witnesses. Ms. Taylor didn't have copies for the judge. Judge is like, hey, man, where's my copy? And I expect you to, you submitted 1,000 pages of stuff. I only want the pages you want me to reference specifically. So they tried to do it by putting them on the Elmo. Anyway, first witness they call, Brett Payne. He is the detective corporal at the Moscow Police Department. He's kind of the lead detective. He was assigned as the lead detective after 24 hours in the case. He's testifying first at this hearing. They asked him, and when was the first time you heard Brian Kohberger's name? The first time I heard Brian Kohberger's name was December 19th, 2022. And what was that a result of? That was the result of the investigative genetic genealogy that was being undertaken by the FBI. We had a phone call that evening, and we were told Brian Kohberger's name. And before that, Mr. Kohberger was not on your radar? The officer said, no, ma'am. Before December 19th was the FBI CAST team member co-located with you? Yes, ma'am. They kind of go through the team members, not really important. By the time it's December 19th, it was the first time you heard of Brian Kohberger's name. Had you reviewed videotapes? Yes, ma'am. How many hours did you review? Oh, a lot. Then they had nicknames of cameras. Question, how you nickname the cameras? Well, so first from the 1112 King Road, there was a surveillance camera, the exterior surveillance camera on a house that was immediately to the northeast of the 1122 King Road. There was some footage from Linda Lane camera. I forgot the address off the top of my head. There was footage from the A&W, which is at the corner of Louder and Main Street on Highway 95. There was footage from an address on Indian Hills. There were also footage from a Ridge Road camera. And that's how we refer to them, as basically those names. Okay. And which one of those cameras were you focused on before you learned Brian Kohberger's name? Well, I would say all of them were of importance. And it was later that other cameras became important. Is that right? Those were the main ones that we relied upon for vehicles, in particular those ones on the road. Okay. Then they talk about how they got around to pursuing the genetic genealogy. Did you have any role in deciding to pursue investigative genetic genealogy? Yes, ma'am. I was a collaborative decision person amongst the command team. Okay. Then they contacted this Otham Laboratory, OTHRAM Laboratories. They began the work on the investigative genetic genealogy. All right. They talk about the work they're doing. Anyway, so he believes that after the fact, we received Kohberger's name, we received documents, but I don't remember what they were. Do you know how many documents related to the IGG you received from the FBI? No, ma'am. I believe it's part of the discovery. It was in the thousands of pages, but that's the best of my knowledge. So once you have Mr. Kohberger identified, what's your understanding of what that meant to have his name? So the only thing that was given to us was Brian Kohberger's name. That was it. It was conveyed to us by the FBI that it was to be taken as no more than a tip. That was it. So once we received his name, we set about doing basically an independent verification of whether or not he was involved in the crime. So December 20th, if memory serves him correctly, they had a secondary meeting with the FBI via Teams. But he doesn't remember all the details about it. The conversation, to be honest, is above my head. But they essentially worked their way through the family tree and arrived at a conclusion that Brian Kohberger was a person we should look into as a tip. That's the extent of his knowledge about that. Well, how was Brian Kohberger, the name you received, a tip linked to this case? Well, he wasn't until after December 19th. What items of evidence did they link Mr. Brian Kohberger to? I'm not sure what you're asking. As before the December 19th, is that what you're referring to? Yeah. We didn't have one at that point. Well, why did you become interested? Not quite sure I understand your question. We were interested, though, in anyone who would have been involved in this case. The DNA from the knife sheath was obviously the one thing we had that we thought was a very strong piece of evidence in this case. So it was that particular piece that we pursued as a potential avenue of identifying the suspect. So is it your understanding that the FBI's work said that it was Brian Kohberger's DNA on the sheath? That is not my understanding. Remember, knife sheath, and we'll talk about it. And they talk about it right here, little button. What other true crime show does the host have his own K-bar that he's had since 1988, ladies and gentlemen? Only one that I'm aware of. right here. I had to go pull that out of storage when this case broke years ago. Thank goodness this knife has not jumped up and attacked either Frank or myself. Frank, the hardest working man in show business. You know what I mean? All right. That's not my understanding. My understanding is that the FBI concluded that Brian Kohberger was a possible source of the DNA, and we should look into it. They did not, to my knowledge, at any point say Brian Kohberger's DNA is on the knife sheath. That was never conveyed to this officer. But they started already looking into him. And what you found is that he didn't have a criminal history. Is that right? Correct. Talk to me about going to Pennsylvania for the trash pull. Well, I was not in Pennsylvania for the trash pull. Okay, I'll ask somebody else about that later. You pursued interviews. Yes. Had you pursued evidence found inside the scene at 1122 King? Yes, ma'am. What efforts did you make to pursue unknown male B? You have to be more specific. I don't remember exactly where unknown male B came from. If I told you the lab report showed unknown male B came from a blood spot on the handrail going between the second and first floor, does that help jog your memory? Little refreshed recollection right there. Yes, ma'am. Why did you not pursue that person? Well, at that point in time, we had already received Mr. Kohberger's name. And from what my understanding was, entering another DNA profile into CODIS would remove the previous one we had from the knife sheath. So if memory serves me, the discussion was, we'll hold off. We'll stay with the one from the knife sheath. If we need to, we can address the unknown male B at a later time. I want to make sure I understand your testimony. Were you not aware of unknown male B until after December 19th when you knew Brian Kohberger's name? No, ma'am. I was aware of that before. Yes. How about unknown male D? Again, you're going to have to give me more specifics. If I told you unknown male D came from a lab report from a sample of blood on some gloves outside the house, does that refresh your memory? Yes, ma'am, it does. You're aware of that too? Yes, ma'am. I want to back up and talk about the affidavits. I think you told me in a prior hearing that you were the person that wrote Exhibit A or the affidavit in support of the search warrants when it came to looking for things about Brian Kohberger. Did I understand that right? Yes, ma'am. And the affidavit, when you began, was that on or about December 23rd to get records? As far as when I started writing the affidavit is what I'm referring to. The first search warrant that applied to Brian Kohberger. I believe it was December 23rd. Yes. When did you begin writing it? Well, I began writing the affidavit long before that. It had been a running affidavit because at the beginning of it, there's the walkthrough of the crime scene where there's numerous things. It was a living document. So we just add information to it. I'd say that document started, I don't know, couldn't give an exact date, a couple of weeks prior to that, even before we knew Brian Kohberger's name. It goes on a little bit here, trying to hit the high points. He talks about, I believe, the first mention of the first component was that Brian Kohberger was pulled over by Corporal Duke on a traffic stop. He was contacted by the WSU police, the Washington State University police. His vehicle was run by officers. And after that, we included his residence, and he had hit LPRs on his vehicle. He had seen on the LPRs between Moscow and Pullman, in Pennsylvania. And then there was the component about where he lived in Pennsylvania. Are you aware because Nicholas Balance was co-located with you, did you, the two of you, continually work on language to satisfy the prosecutors wanted to see for probable cause? Yes, ma'am. Did you and Nicholas Balance produce a map to show possible routes of travel for the suspect? Yes, ma'am. Anyway, so they go on and they talk about then the AT&T records as well, but it goes to like, well, you didn't include all this in the affidavit, so it's like some sort of material misrepresentation. But they're trying to establish probable cause as to this particular person. And even the judge found, hey, even if there's other people there, are you saying your guy there's no probable cause because they found these two other unknown individuals' DNA, on either a glove outside or on the hand railing? No. And it wasn't like, some say, oh, well, gee, there's unknown DNA there. I guess this guy that had the DNA on the knife sheath underneath a body at a quadruple homicide. Well, my God, I just can't find probable cause as to that individual, Brian Kohberger in this case. So you can see why that argument failed. Then they go on, they talk about the phone records, but then we get to kind of a little more interesting part, if I may say so myself. Let's see here. Okay, let's jump up here. And so in doing the affidavit, you have this working document. And I'm going to start with DM. If I say DM, do you know who I'm talking about? Yes, ma'am, I do. And she's one of the roommates. Is that right? Court, we're sealed. You can use the name. I can use the name. Try to get a habit. By Miss Taylor. Redacted. Who is she? She is one of the surviving roommates. And how many times was, quote, redacted, interviewed by law enforcement at the time you wrote this December 23rd report? If my memory serves, it was 4, I think, 3 or 4. In the affidavit, you wrote a statement that she had heard Kaylee go upstairs, yell, "Someone's here," and run back downstairs. Is that correct? Yes, ma'am. And you used the words she thought she heard. Do you remember that? The district attorney interjects. Your Honor, I'm going to object. I'm objecting based on the scope of what this testimony is supposed to be. My understanding was it was limited to solely the issue of the Franks and the IGG. The court, I was just about to ask that question. I don't recall the statements of blank, redacted, being a subject of a motion to suppress separate from the Franks issue. Am I correct about that? Ms. Taylor, that is correct, Your Honor. The court, okay, so we're not at a Franks hearing on that issue. The only issue we are at the Franks hearing is the IGG. All right. Ms. Taylor says, all right. Well, let me rephrase. Let me start from a different place. I'll sustain the objection, the court notes. Then they go back and talk about some affidavits. You put information about the front license plate missing from the Pennsylvania cars. The 1112 video did not show enough of the vehicle that you could see whether it had the front license plate. Is that correct? Response, that sounds correct. So it was after you learned of Brian Kohberger's name that became part of your affidavit. Is that right? So let's talk about the vehicle. You work for Special Agent Emel to identify the vehicle. Was there more than one vehicle identified? I don't believe there was. My memory serves me correct. It was just a Hyundai Elantra. All right. They go up. They don't want to pollute the record. Bench conference. They look to a bolo to identify, go back to the IGG stuff. Nothing particularly that interesting. But I think you can see what they're trying to focus on, but it really doesn't matter. This is for trial strategy. They're trying to work this in. They're trying to get some information, but they're trying to show us, hey, you have all these other suspects and you can't explain why these other two individuals' DNA is in or near the house. But yet you went after Brian Kohberger. Why didn't you go after these other individuals? You formed your conclusion that Brian Kohberger, based upon this tip, the IGG from the FBI, the tip from the IGG FBI, that it was Brian Kohberger. Go after Brian Kohberger, ignore everything else. You can see where the defense is going with this, even in the motions hearings. And that's why I love motions hearings. Everybody wants to wait for the trial, man. Most of the time, the motions hearing determine what is coming in, right? The judge is making rulings on legal issues. That's what judges do. Questions of factor for the jury. The judge is saying this is coming in or it's not. It frames the case. Anyway, so we go on. Cross-examination by the prosecutor literally, I think, asked one question. It wasn't that big of a deal, for certainly not testifying to about. Then a person by the name of Rylene Nolan testifies. And this person was with a forensic laboratory manager with the Idaho State Forensic Services Laboratory in Meridian, Idaho. Goes on qualifications, blah, 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 blah. Talks about CODIS. They talk about the NSP profile is a single nucleoid polymorphous. So you're looking at a single nucleotide where the STR is a series of repeating nucleotide, a specific repeat, and that's what they're looking for. And they talk about DNA type stuff. But then they get to the interesting thing. All right. Are you aware of a profile called Unknown Male A? Yes. Where did that come from? To my recollection, Unknown Male A came from a swab taken from the knife sheath that was submitted by the Moscow Police Department. Are you aware of Unknown Male B? I believe that was another sample from a previous hearing testimony that was from in the house. I would only want you to testify from your base of knowledge. From my own memory, I don't recall exactly where B was from. Fair enough. Thanks for clarifying. Then they go back and talk about investigative genetic genealogy. Once again, they talk about their memorandum, working with the DOJ, talk a little bit about policies, basically saying if somebody's arrested and there's a prosecution, all the items in the forensic investigative genetic genealogy should be preserved for court purposes. Once again, talking a little bit about policy. Question. All right. Did you find male profiles? I didn't perform the actual testing, but yes, there were male profiles developed. How many? I don't know. Do you know anything about either male profile or any of them? I believe one of the male profiles designated as E was determined they could be a biological parent or child of the profile from the knife sheath. And are you aware that Brian Kohberger's DNA was in the trash? I was not aware. Did you become aware? I became aware later. We didn't have his name at that time. You didn't know his name on December 28th? No, I did not. Okay. Were you on December 28th, were you aware that not male E, but of another male profile had been identified from the trash pool? I knew there was some mixture of DNA that were also included. One of the mixtures, did it have a male DNA profile? I believe it did. And wasn't that profile the major component of that profile with a minor female? I believe that sounds correct. And later, did that return to Brian Kohberger? Well, we actually did not perform that comparison. Did you have a discussion a few days? Did you and I have a discussion a few days ago? Did you tell me that you knew that to be Brian Kohberger's DNA? I said, I thought that was, and I could not find the report where we had done that comparison. I've since looked through and we did not make that comparison. So I cannot say that he was included in the mixture. Our laboratory did not do that comparison, but a DNA profile was made for the mixture. Is that right? Yes. And there's a minor female and a major male. That's my understanding. And you, by I, look at that, tell me that Brian Kohberger, couldn't you, if you wanted to? If I wanted to, I could probably look. I did not. I always like those answers. I could have done it, but I chose not to. All right. Well, if there was a request to do a comparison, a visual comparison of evidence, our procedures don't allow us to do that for probative comparisons. Okay. Question. I need you to help me understand a little bit. I'm having that question. I don't understand. There was an unknown male B found on lab item 30. Do you know what I'm talking about? No. All right. Well, I also understand there is a cigarette butt taken from somebody in connection with the case investigation. Are you familiar with that? I am familiar with that. And that was compared to the DNA on the knife sheath. Isn't that right? Yes. And that was found to be excludable. Am I using the right word? It was an exclusion. Correct. So you compared something that was taken from somebody to an item of evidence. Is that right? Well, something that was a secondary reference, as it's sometimes identified it, as they saw that person using that item. They saw that person dispose of that item. That was collected and used as reference sample from that person because there was someone who said that it was from that person. Okay. And when you got the trash to go through in the lab, you knew that you were looking for a male, right? Correct. And you knew that the male and his family member lived in a house that produced the bag of trash. Is that right? Yes, but not who produced each individual item. All right. They go on. When one individual is male, it's not always possible to say the gender of the second person. Males have an X and a Y chromosome. Females have an X. So if there's an X and a Y present, it could be one male. It could be two males. It could be a male and a female. Without comparing to no reference samples, I can't say that. I haven't seen the profile to my knowledge. Did you tell me, though, that it's on that sample, I'm talking about 95.9.1, that was a male and a female? I believe that. I don't know if that was designated as in the laboratory report. To my knowledge, I can't remember. Okay, so they go on. Male E profile was compared to a lot of other evidence in the case, correct? Are you allowed to do the manual interpretation per your policy? Answer. If there is, it's not black and white. So if there's a single source and we can look at that and that person is excluded, they are not the source of the DNA, then yes, that can be done manual. And by manual, I mean person looking at it. And they talk about some mixed profiles. Okay. A little more stuff about the sheath. I think it gets a little more interesting. Like I said, I read all 172 pages, so you didn't have to. Question. Now, at some point later, your lab issued a report saying matching the DNA on the sheath was taken from Brian Kohberger. Is that right? That's correct. And a statistic was provided. Now, I want to talk about what we're talking about when we say the sheath. You're familiar with what happened with the sheath for swabbing. Is that right? I've seen the sheath and I know how our laboratory performs swabbing of evidence, but I did not swab that item of evidence, nor did I see it being swabbed. As I understand it, though, you've read the lab notes. At one point, I believe I did read the notes, and I think I was asked the question and the analyst was out of town or something. And I think you answered that question to law enforcement after consulting everybody else who was with the swabber when the sheath was swabbed. Is that right? That sounds familiar. If I understand the lab report, it is a single source on the knife sheath. Is that right? Correct. Does that mean it's only one person in that area? Yes, that was detected through our testing. Tell me where you think the sheath was swabbed for purposes of DNA collection. I believe the analyst swabbed there's kind of a snap or button on the top of the snap, and that's the area that was swabbed. There were other areas on it sampled as well. Okay, question. For the purpose of unknown male A that you were telling us later came back to be Brian Kohberger, that's the place I want to talk about right now. Are we on the top button, the outside the button, or the inside socket portion of the button, right? Got that one there, right? Right? I know on the top, I don't recall if she swabbed the underside or not. I'd have to look at her notes. Do you know if the sheath was part of that preserved for fingerprinting? The swabbing was done first. That's our laboratory standard order of processing. If DNA is needed and fingerprints, they will work together. Essentially, fingerprints will say, we can see some possible ridge details. So if you can avoid this area after DNA says we want to swab this, and they can come to a decision of what would be the best suit that item of evidence to determine where to swab. So the swabbing takes place first. Then she says, I don't have any questions. District attorney asks questions. As part of those policies and procedures, does the lab need to have a legitimate reason to test DNA? Yes. We only test DNA related to criminal investigations or to death investigations, and it needs to be the item that will answer the probative answer to the questions. We don't do curiosity testing, and none of our testing would provide medical information. Then they go on. Anyway, and how do you hone those areas being particular? Because that's the question we are trying to answer. In forensic DNA analysis, the questions we're trying to answer is, can we link the assailant to victim or assailant, or one or both to the scene? So in this instance, my understanding, the sheath was found at the scene. So trying to link the possible perpetrator to the scene. And why in particular do you hone in on the area where the person may have handled the knife sheath? Well, because so DNA is found in the cells in our body. That included the skin cells that are sloughed off on our hands when items are handled. So looking for any touch DNA is the term that most often used, or someone touching or handling an item. So if I'm understanding correctly, the analyst is swabbing the place that would most likely have that touch DNA. Correct. Go back again, direct by Ms. Taylor. Question. You're supposed to read it and let it refresh your recollection, then read it again. All right. The entire leather portion of the straps, both top and bottom, and then the underside of the button. I misspoke. She did not swab the top of the button because that was determined to be the most likely place for fingerprints to be found. The underside of the button, that the sticky out part would go into, or the sticky out part, or both. I can't tell from this. I would have to look at her notes. Anyway, we go on and on. There's a couple more witnesses. They talked about laboratory procedures, but nothing particularly earth-shattering. And like I said, as we all know now, the judge denied all of the motions for the defense. And frankly, I would have denied it too. If I was the judge in this particular case, I don't think the defense met their burden to show that Brian Kohberger's DNA, that somehow his right to his DNA profile was, that he had a right to privacy in that. Like I said, it's great for writing law review articles of where you think the law may be going. But as criminal defense attorneys, yes, you got to make those arguments for appellate purposes, for, smarter people down the road, so to speak, than those, little silly street lawyers, so to speak. But, it's not going to be a good thing because it's going to get denied. And in this particular case, it should have been denied. And what this case comes down to is, basically what we know. Brian Kohberger's DNA is there. The defense is going to say, you honed in on him. You didn't look at any other suspects. And you can't explain, if you ask the prosecution, you can't explain when and how that item got there. Well, they were all stabbed to death. It was a knife sheath. We didn't find the knife, but I'm thinking one of those Amazon sales is going to include, I'm going on a wild guess here, going to include the purchase of a K-bar. Because remember, that was one of the searches they tried to get rid of, all the Amazon purchases. Yeah, not good. And I know there's the Brian Kohberger is innocent crowd, and then there's the Brian Kohberger is absolutely guilty crowd. Like I said, I'm not in any crowd. I'm just calling the facts how I see them. And I've said this a long time ago, and a lot of people are like, oh, Scott, the facts are, you don't know what you're talking about, Scott. It's not like you ever tried any DNA cases in your life. Yes, I have. And I'm telling you, the 12 people, good and true, selected to be the jurors, are going to say, wow, that's crazy. Brian Kohberger, how did your DNA get underneath the body of a quadruple homicide on a knife sheath where it's missing? And, there may be some evidence that you purchased a K-bar. At least mine was purchased so far long ago that there would be no receipt. Like I said, 1988, ladies and gentlemen. Got this after I went to boot camp in 1988. My God, that makes me sound old. And the fact that I still had it in a duffel bag, the C bag, in my garage, and when this case broke, I said, I got to get the K-bar out. And frankly, I think they are terrible, terrible. I know they were standard issue, World War II, Marines, everybody wanted a K-bar. You could do so much better. I mean, they're tough and rugged, maybe for digging a hole in some gravel, but they don't stay very sharp very long. So, and I don't think they come very sharp. I've never seen a sharp K-bar in my life. I have a better chance of getting hit on the head and knocked out by my K-bar than probably being stabbed by it or cut myself on it. So anyway, we'll have to wait and see. We're going to have to wait and see. But Brian Kohberger's got some problems for trial. Let's just be realistic, right? Like I said, as a defense attorney, you cannot ignore the bad facts. And, we joke sometimes, and I've told you this joke before. Why are we going to let the facts get in the way of a great defense? You get in that trial psychosis. I can win this. Sure, they got my client's DNA on the sheath that just happens to possibly match, the forensic pathologist is going to say be consistent with a K-bar. I haven't seen it. I'm just guessing that's what they're going to say. They got some doctor saying, could it have been possibly something that would fit into this knife sheath, a K-bar? Yes, I have. Have you examined a K-bar? Would you think that would be consistent with the injuries? Why, yes, I have. What a coincidence, because we think we probably have Brian Kohberger purchasing something on Amazon, which, the defense filed a motion to suppress because it's bad evidence. Let's get for real, ladies and gentlemen. And don't get me wrong, I love good lawyering. I want to see a very interesting trial. I want everybody to be hanging on pins and needles. But that little DNA is what it's going to come down to, ladies and gentlemen. That little itty bitty DNA is what it's going to come down to. All right. Can you believe how quickly that went, ladies and gentlemen? I cannot believe we've been going an hour and 17 minutes. We usually only do an hour, but we had so much to talk about tonight. We had so much to talk about. We had Kare Read, Brian Kohberger, right? And just jumping back to Kare Read, I'm telling you, I've said this before, and I would have voted her not guilty based upon the evidence that was presented at the first trial. Okay, so I'm not in the I hate Kare Read camp. Let's just qualify that. I would have said not guilty. I don't think they proved her case. I think reasonable doubt was raised. But I've also said, and I'll say it again, the defense never does better the second time through. And look what is happening. The defense case is falling apart. Mark my words, ladies and gentlemen. It's going to get ugly for Kare Read this time around. It's going to get ugly. And Kare Read, let me give you some quick advice, free advice. I'm not your attorney, but what have we said many, many times here? It's the number one of the 12 undeniable truths of life from a criminal defense attorney, Kare Read. There are two types of people in the world, those that are humble and those that are about to be. I think I'd be walking a little more humble going into that courtroom rather than telling the press and holding Super Bowl news conferences or interviews on Super Bowl Sunday that basically you have been wrongfully accused, but you didn't have enough guts to get up there and testify under oath. I'm just telling you, be humble. Be humble, Miss Read, because I think it's going to get ugly. So the Kare Read never does anything wrong crowd, I know, bring it on. Bring it on. I'm just telling you, if that was my client, I'd be telling her, man, you need to sit down, shut up, get that resting bitch face off of your face. She looks like she's bored every time she goes to court. She rolls her freaking eyes. I'm telling you, judges, juries, notice that stuff. Had a trial not long ago. Kind of difficult. Client, blah, 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 blah. got back to me. The jurors told the judge. Did the defense tell their client to, like, not react to every question and everything? It was a little distracting. They noticed that stuff. So I'm just telling you, sit down, shut up, look humble, look interested, but let's face it, you're probably not testifying. Because she said, I think in one of her interviews that she, mistakes were made. And looking back, I wouldn't have done it. She admitted to drinking, right? Nothing's going to come from that. I'm telling you, this Brennan guy from the Kare Read Can Do No Wrong crowd, look what he's already done to the case. He's already exposed that these experts maybe weren't truthful on the stand. The other lady, the dog bite lady, the pathologist, the only time she's ever, this is her first time opining that this was a dog that did this. And she can't say which kind of dog did this or anything like that. No peer review, didn't look at all the discovery. He's already whittled this out, and he's doing it brilliantly in the sense that it's already getting out there to the news. So if we're hearing about it, imagine what the people in Massachusetts are hearing about, right? Because they hear about this even more than everybody else. They're probably paying attention to it. So I'm telling you, I can't wait. I hope Mr. Jackson doesn't get admonished. I think he's going to get admonished orally. And I think that once the judge gives him that tongue lashing at the end of the case, no matter what happens, if Kare Read is found not guilty or if she is found guilty after sentencing, get that ethics attorney fired up, because I think you're going to have some bar complaints from the judge. And you don't want that. Nobody wants that. But you have a duty of candor to the court. And if they say, did you pay them for your testimony? And your response is, I did not pay them for their testimony, Your Honor. I simply paid them for their time. I'm going to go on a limb here and say that's a material misrepresentation in violation of the rules of candor under the ABA Model Rule 3.3a. You paid them $24,000, $23,500, $600, something like that. $24,000 for their time. Really? Because I thought they were doing this for free. And I thought they were doing this just as a, good public service to these particular, to get the truth out there, right? And then they send a bill for $24,000 and you pay it, right? I've gotten some big expert witness fees afterwards, but I knew they were coming. And I paid them because they were my experts. Even if I didn't have them testify, and they charged me for sitting in the hallway for 2 days. We paid it because they're entitled to it. But I assure you, I've never paid a prosecution expert just because, well, I thought I'd chip in a little bit. No, you don't do that. It's weird. It's weird. It's they're your expert. And the fact that you played it off at court, like if we've never met before and I've not paid you anything, you're just here as a good Samaritan to get the truth out. Isn't that true, jury? Oh my gosh. And you argue it in closing. Ladies and gentlemen, we didn't pay these people. They're here because of this travesty of a mockery of a sham. And we're not going to let this injustice take place. And that's why they're here. They feel so strongly about it. And you should feel that strongly about it too. And then you find out, what is it? I think it's Jefferson Airplane. I love, there's those lyrics that say, when you find out the truth has been a lie, or something to that effect, right? And it's not exactly what everybody thought it was, right? You've been lied to. You've been lied to. And just like that case, the Supreme Court threw out a case because the prosecutor knew their witness wasn't being truthful, knew it, and they should have corrected it. And here, not only did the defense attorney know that there had been communication with the experts from ARCA or whatever the hell they pronounce it, he exacerbated, perpetrated, that they had never met, that they have never communicated, have no idea what your testimony is. I'm just getting up here working without a net. So if I fall, it's going to be ugly, but that's who I am for my client. It was a fraud. It was not truthful. It was a material misrepresentation to the court. The question is, what's the judge going to do about it? Sanction him now or later? But there's going to be a sanction. Mark my words. So let the comments begin. From the Karen Read can do no wrong crowd to the Karen Read is guilty crowd. Let me know what you think. All right. Same thing with the Kohberger is innocent and framed crowd to Kohberger is guilty crowd. Let me know. They got the defense in this particular case. I hate to say it. Reed's overplayed her hand. She needs to be humble because she's about to be. Kohberger, he had one shot, man. He had one shot. And that should have been to go to trial in that speedy trial. And I know there was a lot of stuff, but they should have had that conversation. Said, man, tell me if you did it. And if you did it, let's go within speedy trial. And I'll work 24/7 until that date because there's no way in hell that that prosecution was been ready. And I think Brian Kohberger is going to be convicted, at least from what I've seen so far. And obviously, we got to give him the presumption of innocence, but you got to be able to explain that DNA. All right, ladies and gentlemen, if you would like to continue the conversation, and we'll have the call-in line up, be a Patreon member, join us in just, I say 5 minutes. We'll be there and we'll do our Patreon show. So thank you for watching our Tuesday Night Live program. I hope you enjoyed it. We know you could have been doing other things, so the fact that you decided to be here with us does not go unnoticed. It is greatly appreciated. Have a wonderful night, and remember, the Constitution